On March 7, 2024, defendant John Gerardo Shaughnessy was charged in the Harris County Criminal Court, Texas with one misdemeanor count of driving while intoxicated under the Texas Penal Code Section 49.04. The charge stemmed from a 911 call placed by Sonic Drive-Thru employee Raquel Castillo, who reported that a vehicle containing a male and a female had struck a portion of the drive-thru property, and that the occupants had attempted to order alcohol. Responding to the vehicle's registered address, Officer Brooks Spash of the Deer Park Police Department located the vehicle in a driveway, initiated contact with a male standing near the driver's side door, and subsequently placed Mr. O'Shaughnessy under arrest after allegedly observing signs of intoxication. On October 23, 2024, trial commenced before Judge David Fleer. Student prosecutor Alex Michias argued for the state alongside Assistant District Attorney Michael Haddad, while defense attorneys Tyler Flood and Savannah Luna represented Mr. Roesi, who immediately opened proceedings with a motion to suppress, challenging the legality of the police detention. However, before the jury was brought in to begin proceedings, the defense raised a threshold procedural objection regarding the state's student prosecutor qualifications.
The only other thing I would put on the record is I understand Mr. Macias is practicing under a supervised bar card, and he was gracious enough to send us that letter. Ms. Luna was the same, and I looked up the rules about what they can do, and some judges didn't think she was able to do. It is from the state bar, and it says that you must be practicing under a supervised attorney, but they actually list Ryan Free. It says supervising attorneys, and it says Ryan Free. And that's the only attorney that the state bar lists can be supervising him.
That can be supervising Alex.
On his supervised status letter from the state bar.
He's another chief judge.
So we looked at this heavily. We had a long conversation with Judge Wright. There is a provision for remote, just to be completely candid, for remote supervision. And I actually called the state bar about that. And Miss Luna was in here trying to obtain a reset. I was across the hall, and they said there's no problem with that. If she can contact you by text, she can call you. It's not a hearing. So that was remote supervision. But for me to not sit with her during a trial, you can't remotely supervise them throughout the entire trial. They'd have to be on the phone with you the whole time.
So you're objecting to his presence then?
Yes.
So
I don't think it allows for him to try a case. Just going by the letter, it says specifically Ryan Free. It's the only attorney listed as the supervising attorney.
So Floyd, can you do me a favor? The statute that allows Alex to practice under a supervised attorney, does the wording state that as long as there is a supervising attorney, or is it only the person that signed their bar card?
Show me what you have so I can see it.
Yes,
It's not a statute. It's in the
Yes. My apologies. Yes.
I think if it said the Harris County DA's office, it would have been.
and with respect to everyone here, and I don't mean to be rude,
Judges,
it also has to be someone that's been practicing for at least 3 years to supervise him.
Do you want me to email this to all the parties?
Yeah, or show me what you're referencing.
These are called the rules governing the supervised practice of law by qualified law students and qualified unlicensed law students, law school graduates in Texas. And then if you go to rule.
Alex, are you still in law school now?
Yes, Your Honor.
What year are you?
A third year.
The supervising attorney has to be an active member of the State Bar of Texas in good standing who has practiced law in Texas for at least 3 years. And so.
Has he not practiced law?
I have no,
And
and that's what I was asking if he.
Haddad, how long have you been
No,
practicing?
2, Judge, but I'm just reading some of the rule. One moment.
Yeah, and there's a duty to immediately notify the state bar membership department if the lawyer no longer meets those requirements of these rules.
Do you want to reach out to Beadle and see what he says real
Can you
quick?
give me 1 moment? Judge?
Of course, take your time. Just not too long because we get the jury, but yeah.
Mr. Flood and Miss Luna raised a preliminary objection regarding student prosecutor Mr. Michias's authority to conduct the trial. Under Rule 7 of the Rules Governing the Supervised Practice of Law in Texas, a supervising attorney must be an active member of the State Bar of Texas in good standing who has practiced law in the state for at least 3 years. Furthermore, Rule 4 requires the supervising attorney to physically accompany the law student during courtroom trial proceedings. Because Mr. Haddad had only been practicing law in Texas for 2 years, he failed to satisfy the mandatory 3-year experience threshold required under Rule 7. Consequently, Judge Fletcher ruled that Mr. Haddad could not serve as Mr. Michias's supervising attorney for the trial, prompting a recess for the prosecution to secure qualified supervision. Later in the proceedings, designated supervising prosecutor Ryan Free entered the courtroom to fulfill the statutory supervision requirement, allowing Mr. Michias to proceed. Following opening statements from both Mr. Mias for the state and Mr. Flood for the defense, the prosecution called its first witness, Ms. Castillo, to the stand. During direct and cross-examination, Ms. Castillo affirmed that she observed a male driving the vehicle in question. However, she was unable to identify the defendant as the driver. Following Ms. Castillo's excusal, the state called Officer Spash as its next witness.
Good morning, Officer Squash.
Good morning.
Can you please state your name for the record?
My name is Officer Brooke Squash.
And Officer Squash, what is your occupation?
I'm a police officer.
And are you a certified police officer in the state of Texas?
I am.
And how long have you worked with Deer Park as a police officer?
Currently, almost 6 years.
So, when you first began this investigation, what was the date of the offense?
Can I refer to my report?
Yes, officer.
The date of the offense was March 7th, 2024.
Okay. And was that investigation prompted by a call from dispatch?
Yes, it was.
And what information did dispatch provide?
Dispatch relayed that a couple, a male and female, were driving a motor vehicle in the Sonic area. They had come to the drive-through and were trying to order alcohol through the drive-through and had struck a portion of the building with their vehicle. They also provided a license plate.
And was the call about a possible intoxicated driver?
The call initially came out as a possible intoxicated driver, but the caller was giving information regarding failed to stop and give information for a possible accident as well.
So, officer, what are the first steps in investigation when you receive this information from dispatch?
The first step was to run the license plate to see if we could figure out who the vehicle belonged to or where the vehicle's registered owner was.
And officer, what information did you obtain when you ran the license plate?
After running the license plate, I was able to determine that the owner was the defendant who I've come into contact with before. I additionally was able to observe the address of the registered
Your
owner.
Honor, I would object just to relevance on what the officer just testified to.
State your question.
Just what information did she obtain when she ran the license plate? And if you could continue, you were talking about the address. What information did you obtain when you were talking about the address?
Sure. I was able to observe the address of the defendant and noted it to be a place that I had been before.
Objection, Your Honor. May we approach?
During direct examination, Mr. Flood objects to Mr. Mias's line of questioning after Officer Spash testifies about her prior knowledge of the defendant's residence and past police encounters at that address. Under Rule 41 of the Texas Rules of Evidence, evidence is relevant only if it has a tendency to make a fact of consequence in determining the action more or less probable than it would be without the evidence. Under Rule 42 of the Texas Rules of Evidence, irrelevant evidence is strictly inadmissible. Furthermore, evidence of prior police encounters or extraneous acts is generally excluded under Rules 44b and 43 to protect the defendant from unfair prejudice. By raising an immediate objection and requesting to approach the bench, Mr. Flood sought to prevent the state from introducing potentially prejudicial history that bore no legal relevance to the incident at the Sonic drive-thru. Judge Fleer granted the request and ordered the jury to step out of the courtroom to prevent any unfair prejudice.
Madam Officer, my only concern is this case. I don't want you to get into anything about any kind of prior knowledge, prior context, anything of this nature, please. Anything, this case, it only resolves what you saw, what you encountered here, that's it. Okay?
I'd move for mistrial.
Okay, well, it's denied. You know, I don't think that it rises to the point where it's that kind of error that it would require mistrial. But like I said, if you'd like to, I could admonish the jury not to.
It would do more
Yeah.
damage to address it with the jury, so I'm not gonna ask them.
But I mean, I'm gonna admonish you, if you get into stuff like that, I will. So no, anything about any kind of prior context, whatever, just, okay?
Judge Fleer denied the motion for a mistrial prompted by Mr. Flood. A mistrial is an official court order that renders a trial null and void before a verdict is reached. Typically declared due to an incurable procedural error, jury misconduct, or the introduction of severely prejudicial evidence that prevents the defendant from receiving a fair trial. In this instance, Mr. Flood argued that mentioning prior contacts or background knowledge regarding the defendant was inappropriate and prejudicial to the ongoing proceedings. However, Judge Fletcher denied Mr. Flood's motion, ruling that the error did not rise to the severe threshold required to halt the entire trial. To address the improper reference, Judge Fletcher offered to issue an instruction to disregard, which is a formal curative directive ordering the jury to exclude inadmissible testimony from their deliberations entirely. However, Mr. Flood declined the instruction as a tactical choice to avoid drawing further attention to the prejudicial statement, including that the error did not compromise the fundamental fairness of the trial. Judge Fletcher denied the motion for a mistrial and ordered the jury back into the courtroom to resume proceedings.
You said you obtained the address, the registered address of the vehicle. Did you go to that address?
Yes,
As you were going to that address, did you observe a vehicle heading to that address?
yes,
Did you observe the vehicle turn into the driveway?
yes,
Were you able to observe the driver exit the vehicle?
I was able to observe the driver at the driver's side door coming up, but I never saw anybody behind the wheel.
And officer, when you approached the address, was the vehicle still running?
No,
Was the vehicle turning off?
yes, the brake lights were still illuminated as if the vehicle was turning off and, everything was shutting down.
Were you able to see the vehicle pull into the driveway?
Yes, I observed the vehicle pull into the driveway.
The driver, were you able to make contact with the driver?
I was,
Is the driver in the courtroom today?
yes,
Can you identify?
No, I object, that calls for speculation. The witness testified she never saw anybody behind the wheel.
Your Honor, she says she observed the driver, the person outside the driver's side, and she can state why she believes the person to be the driver.
No.
I can-
Did she see him driving?
And I can ask additional predicate questions.
See if you can, did she see that, who was driving?
That question has been asked exactly in that clear manner, and she stated, no, I never saw anybody behind the wheel. She said she saw a man out in the driveway, and the car was off.
She didn't see him drive?
Officer, is it your opinion that the person you observed was driving?
Objection, that is leading, and that calls for speculation. She's already answered that she did not see anybody driving.
Same.
Officer, did you form an opinion as to who the driver was?
yes,
And what was that opinion based on?
Objection, this calls for speculation, Your Honor.
How?
Was there anyone else in the vehicle when you observed it?
no, it was not.
And what was the time period between when the vehicle pulled in the driveway and when you observed the person outside the driver's side?
Seconds.
And did you confirm this was the same person the vehicle was registered to?
I did.
Did the person have the keys to the vehicle?
I don't remember.
And based on those observations, did you form an opinion as to who was driving?
I did.
And who was the driver of the vehicle?
Objection, that calls for speculation. She already said.
Sustained.
Thank you.
When you spoke to the driver, where did you make contact with the driver?
Objection, now this is objection to relevance now because we've established she can't identify who the driver was. So any questions about what happened to the driver, she can't identify the driver. So I object to relevance. The question was, what did you do with the driver? She didn't identify, she didn't see this person driving.
She has laid the groundwork through circumstantial evidence as to how she formed her opinion as to who was the driver.
This is not a circumstantial game. It's not. And I'm sorry, Mr. Free, you know?
Mr. Flood repeatedly objected to Mr. Mia's line of questioning on the grounds that it called for speculation and lacked personal knowledge. Under Rule 6002 of the Texas Rules of Evidence, a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of it. Furthermore, under Rule 7001 of the Texas Rules of Evidence, lay witness opinions or inferences must be rationally based on the witness's direct perception. In a trial, speculation occurs when a witness offers testimony based on guesses or assumptions rather than observation. Mr. Flood argued that because Officer Spash explicitly testified under oath that she never observed anyone behind the wheel or operating the vehicle, any question asking her to identify the driver lacked proper evidentiary foundation. Since she did not witness the act of driving, referring to the individual in the driveway as the driver required an impermissible inference. Following these sustained objections, Judge Fleer declared a brief recess and excused the jury so both parties could resolve the foundational issue outside their presence.
You wanted to say something?
I'd like to move to suppress the detention for it being illegal and just recite what we know so far. The 911 caller from Sonic stated that they did not give any physical description of who was driving, stated that there was a man and a woman in this vehicle, stated that there was that they damaged their mirror by running into the drive-through, and they turned left out of the restaurant. Officers, well, she didn't say it yet, but she went the other direction, and she even they state that so they ran the license plate, and on a hunch, they went to, here's kind of the full story, that she did have previous encounters with him, and she said on a hunch, when they saw that plate came back to him, they went directly to where they know he lives. And they wrote in the probable cause affidavit, they saw him exiting the vehicle, which is not true. And there's an interview with the state, with Alex, where he talks to both of the officers, and they both say, no, we did not see him exiting the vehicle. So we have that problem of no identification whatsoever. She couldn't identify him in court from the Sonic call. But then they go to his house and
Into his house?
they go straight to his house. They don't even go the direction the Sonic person said that the vehicle left. They go westbound. The vehicle was reported to have gone eastbound. She drives over to his house because there's history, and he said that they've been to his house before. They mess with him. They mess with people that are over there. That's kind of, they knew him. But she wrote that in the
hearing right now.
No.
she wrote that in the probable cause affidavit too, that she has encountered him before and she knew him to be an intoxicated driver, for what it's worth. She wrote that in the PC affidavit. That's why she went to his house when she got the name. But she said, I never saw anybody behind the wheel. There was only one person in the vehicle, and the reportee said there were two. They were able to, never saw anyone behind the wheel, observed a vehicle. Was there anyone in the vehicle when you approached? She said no. She said it was off. And then asked if he had keys to the vehicle. She said, I can't remember. No identification of him. Oh, and here's the other piece of information that is really important. If there was going to be some other evidence that he was operating or that was the truck, look for the damage on the mirror. They do that.
My only concern
There's
now.
no damage though.
Concern now. Do we have a witness that sees him driving?
I mean, obviously,
Yeah.
that's a lot to respond to. I'll just take it about the issue that's at hand, right? Wheeling the defendant, okay?
I don't care about all the extraneous crap. I don't care. My only issue now, because really,
I'll let you the judge. We're relying on the basic premise that the law does not require absolutely a person watching the person behind the wheel. They can still be wheeled, legally speaking, sufficiently through other means, both through an admission, their own admission, and then through other circumstantial evidence. We're getting in both the admission of the defendant who admits to
but you
driving.
can't get to the admission.
That's what I'm saying, is we've got to lay the groundwork there in order to get let the officer testify to all of what she saw, all of the things that Tyler's bringing up. Some of them are partial truths, and maybe they're worthy of being impeached on. Maybe not. We're going to let her testify. The jury should be allowed to hear her testify and decide what is credible and what's not. She's going to testify to what she saw, and she's going to make it very clear there's literally no one else that could have been driving the car. There's just not. Same thing as if a person comes on an accident in the middle of the road. In the
There's
middle of
still a
nowhere, there's no
hunch.
one there.
It's a hunch. Sure.
She's going to testify that she watches the car drive up into the driveway. She's going to testify to you that she watches a male get out of the vehicle. She's going to testify that she doesn't lose visual contact with that person. She's going to testify that she watches the brake lights go off. She's going to testify that this woman that was talked about is there. She's on scene. Tyler's aware of this. I know he's aware. He's read the OR. She's sitting on the porch of the house. Right. So she's going to, if we give him the chance, she's going to testify to all of this. This will lay the groundwork to get in at least her body cam when she speaks to the defendant, and you can hear from him himself about what he was and wasn't doing. He'll make plenty of statements on that.
You said there could be nobody else possibly driving, and now you're saying there's another woman at the scene.
Already there when the car pulls up, Tyler. She's on the porch.
Not according to the Sonic people, though. She said that there were two people in the car.
I understand
Didn't
that.
give any physical description. Could not identify him in the courtroom after 7 times asking.
So listen, the Sonic is why
Judge,
the
just
officers
to-
begin. I'm not finished. The Sonic is why the
There is no
officers begin
witness that can say
investigating.
this on driving.
You can't talk when he's talking. I can only take one.
Tyler,
Sorry.
let him finish.
Sonic is why the officers initially investigate the defendant. That's clear, right? There's the 911 call, even though she was unable to state that she recognized the person in the vehicle on the record. She calls 911, she gives a description, she gives the license plate of the vehicle that she saw with the person driving that ran into the Sonic. Police get the dispatch, they run the license plate, they recognize the person. They go to that person's residence.
And there's the problem.
Why?
They recognize and they assume who that person is. There's two people in the car. They're making an assumption.
She said that there was the witness just said there was a male, an older white male driving.
Your Honor, if I may, the 911 call does not identify who's driving. So she doesn't know who's driving when she gets dispatched. She doesn't know if a man or a woman's driving. If we listen to the 911 call, she just says there was a man and a woman in a vehicle.
And she writes on a hunch.
I don't think it survives a directed verdict. I don't.
I don't want to waste the court's time, Judge. We're going to get testimony from the officer about all of the circumstances of what she did and didn't see. She's not going to testify that she saw this defendant specifically behind the.
I don't
She's
think
not
it's
going to.
relevant.
Okay, so then is it the court's position then that based on the testimony and your rulings on the evidence thus far that you wouldn't allow in the remainder of the testimony such as body worn camera? Okay, then I'll follow.
Sorry.
I'll dismiss.
Yes, Your Honor.
All right. That's it.
So a motion to suppress the detention.
Thank you, Your Honor.
Judge Fleer granted the defense's motion to suppress, ruling that law enforcement lacked reasonable suspicion for the detention and that the state failed to provide sufficient identification to establish that Mr. Rossi was the driver of the vehicle. Mr. Free contended that Texas law does not require an eyewitness to physically observe a suspect behind the wheel to establish operation under Texas Penal Code 49.04. He contended that the operation can be legally established through circumstantial evidence, defendant admissions, and officer body camera footage. But according to Mr. Flood, either Ms. Castillo nor responding officers were able to identify Mr. O'Anasey as the person who drove the vehicle at the Sonic drive-thru, and the probable cause affidavit claimed that officers observed the defendant exiting the vehicle. However, during a recorded pre-trial interview with Mr. Macias, the officers contradicted their own paperwork, admitting they never saw Mr. O'Anasey exits or drives the vehicle. Also, Ms. Castillo explicitly reported in her 911 call that the suspect vehicle fled in one direction, bypassing the reported route entirely. Officers drove in a completely different direction straight to Mr. Ashinoa's residence based solely on a personal hunch and in prior encounters. On the same day, Judge Fleer granted the motion to suppress and the case was dismissed. This case illustrates the critical importance of first-hand witness testimony, law enforcement investigative rigor, and prosecutorial adherence to evidentiary standards. Since Ms. Castillo was unable to identify who was the driver, and officers failed to conduct a thorough investigation from the outset, the state lacked a legal basis to secure a conviction against Mr. O'Anasey. Evidence of prior police encounters cannot serve as a substitute for proof of guilt in a new charge. During trial, Mr. Tyler Flood ensured that the state adhered strictly to courtroom procedure and did not present impermissible speculation about his client. By holding the prosecution to its heavy burden of proof beyond a reasonable doubt, the defense demonstrated how critical it is to attack the foundational elements of a charge for a case ever reaches a jury. Ultimately, impartial judges like Judge Fletcher reinforced the integrity of the judicial system by keeping trial proceedings fair, grounded in law, and unbiased. Comment below if there is a case that you would like us to cover. Thank you for watching and don't forget to subscribe to more.